Good morning. This isn't, I'm going to make this a pre-recorded video as opposed to a Facebook Live video because it's on the matter of Orbital ATK versus Walker, which was decided back in July 12th, I believe it was. I talked about this in my briefing letter to the press in a letter I sent out about 3 weeks ago. But I just wanted to give everybody a quick update and a quick synopsis of what the court's opinion was. The case was Orbital ATK versus Walker, aka DARPA, which involved a satellite servicing technology for satellites in geosynchronous orbit. And basically what happened was DARPA basically sole sourced this technology out to SSL Loral. Orbital ATK wasn't happy about this situation and decided to sue in federal court. Now, mind you, they didn't sue as a bid protest in the Court of Federal Claims, but they came right out using a statute called the Administrative Procedures Act, which basically is an act that's designed that gives the court power to review decisions by executive agencies like DARPA. And essentially what Orbital ATK came out and said is that it was inappropriate for DARPA to make this decision to sole source the award, sole source this technology to SSL Loral, and they went through and they really criticized the whole program itself, not just focusing on the agency decision, and that kind of bit him a little bit late, as I'll discuss later on. But interestingly, and I think more significantly, is they took the National Space Policy of 2010, which is still officially the current National Space Policy until it's superseded by the Trump administration, and they said that they took the precepts dealing with commercial space and the mentions in the National Space Policy about farming out different projects to commercial space. They basically said those precepts and the National Space Policy itself has the force of federal law, in other words, a federal statute. This is a very significant assertion, and basically it really opens up some troubling questions, and I'll touch that a little bit later also. DARPA and through the DOJ, because the DOJ basically is the attorney for the United States government and the executive agencies, it came back very hard with a motion to dismiss, basically saying one thing: one, the court didn't have subject matter jurisdiction because the APA didn't apply in this matter, and two, Orbital made a claim that it couldn't substantiate. In other words, the way its complaint was filed, it didn't state a claim that relief could be granted on, therefore the court should dismiss it. And specifically, they focused very heavily on the National Space Policy's status as, quote, law, and basically attacked it, saying, no, it's not law. So there were a few other motions went back and forth, and finally on July 12th, the court issued its decision and ruled in favor of DARPA, and basically dismissed the case both on the counts of subject matter jurisdiction and failure to state a claim for which relief could be granted, which was the second count under the federal rules of civil procedure. I'm just going to touch the subject matter jurisdiction count very lightly. Basically, subject matter jurisdiction is the ability of the court to legally hear a matter and to adjudicate a matter. Congress basically, the lower federal court, Congress basically gives the federal courts power over what they can actually adjudicate. In other words, which Congress through statute says the federal courts have this power. The only federal court that is actually granted power by the Constitution is the Supreme Court, and all the other lesser courts are given their power by Congress. So what the APA does, it grants that through statute, Congress grants to the federal courts the ability to adjudicate or review agency decisions for whether they're arbitrary, capricious, or otherwise have made sense. So basically the court came back and said, look, we don't have subject matter jurisdiction under the APA because Orbital never really attacked or discussed the agency decision to award this to SSL Loral in the first place. Their whole argument was basically an attack on the program itself, the satellite servicing technology program itself. They didn't narrow down and focus on the agency decision itself. Therefore, there isn't a complaint here that falls under the APA. Therefore, the way they filed the complaint, we don't have the subject matter jurisdiction to hear it. So automatically, that kills their case in their entirety. And they really didn't have to go on and talk about the National Space Policy having the force of law. But fortunately, they did, because I think it's very critical. Essentially, they looked at the arguments of DARPA about the national space policy being directives for executive agencies, and they did a nice analysis of the history of national space policies and executive orders, and cited some very good source material in their deliberations. They basically came down and decided, look, the national space executive orders in some cases do have the force of law, but in this case, the national space policy is a directive for executive agencies. In other words, and they're saying basically that doesn't say all executive orders like the national space policy won't have the force of law, because some could, but in this instance, there is no indication that Congress ever intended to give the executive branch the authority to create binding law through the national space policy. Therefore, the national space policy can't have the force of law. This is laid out very good in the complaint, and they did an excellent argument. They spent about, I think almost 9 pages discussing their rationale, and they supported it very nicely. So basically, they came down, because the national space policy doesn't have the force of law, they also dismissed Orbital's case for a failure to state a claim upon relief can be granted, which is what we call a Rule 12b-6 motion to dismiss under the Federal Rules of Civil Procedure. That's a very cut and dry approach of what happened. Why is this important? Well, the whole thing about subject matter jurisdiction is interesting if you're a lawyer, and I know it interests me because I'm a lawyer, and other lawyers might find the argument interesting in itself. But I think the most critical thing in this whole case was Orbital coming out and asserting the national space policy has the force of law. If the court had decided that it does have the force of law, or if that went unchallenged, it would have left open the potential for other litigants in the commercial space industry to come and say and sue the federal government in federal court, saying, you know what, these programs that you're doing as a government agency, you can't do those. You got to transfer them to us as a contractor and let us adjudicate it. In other words, pay us the money and let us develop it. You shouldn't be doing this, because under the law, under the quote law of the national space policy, you're not allowed to do this. So basically, that's the can of worms that Orbital ATK opened up. Fortunately, the federal court dealt with it, even though they didn't have to, because once the court decides it doesn't have subject matter jurisdiction, that's it. Game over. The whole case is thrown out. But they took that extra step and decided it wasn't, which is critical. What does that mean for terms of legal precedent? Probably beyond the Eastern District Court, probably not much, because it hasn't been appealed yet. Although there's a chance Orbital might appeal it. If this got up to the appellate level and the appellate court decided to take it, chances are Orbital would lose anyways, because the federal court really backed up their decision nicely with the arguments. Now, even though this decision is at a federal court level, if this were to be brought up in another court, say in another district, say in Texas, or in another state in Virginia, for example, or any other state, any other district court for that matter, even though this has very little precedential value, but what we'll call persuasive authority, the fact is, the blueprint is there for the DOJ to defend this and basically say, because the DOJ in this case has done its homework and they have the opinion with all the citing references, and they can go back and they can determine whether or not they can basically fight this very effectively. Like I said, I think overall this is a very foolish decision on Orbital's part to even bring this up. Their complaint was extremely sloppy. They did not bring their A game, but DARPA and the DOJ did bring their A game on this. Like I said, I did go over this in much more detail in a special issue of the Pressy that I sent out about 3 weeks ago to my subscribers. A little advertisement for my briefing letter if you're not subscribed. But it's also, the complaint's also the order is also very interesting reading. So if you would like a copy of the order, of the court's order, send me an email. Michael at spacelawsolutions.com, or just put a comment, below here, below this video here, and I'll be happy to email you a copy of the complaint. I won't email you a copy of the Pressy unless you're a subscriber, but if you decide to become a subscriber, I'll gladly make sure that issue is sent along to you as well. And if you want to become a subscriber, you can go to my website, spacelawsolutions.com, and click on the link for the Pressy, and I have all the information on how you can become a subscriber. Anyways, that's a quick and dirty video of Orbital ATK versus Walker, aka DARPA. Like I said, very interesting case, very crucial decision that the court made with regards to national space policy. The bottom line here is national space policy is not binding law. And oh, by the way, the court also mentioned third parties do not. The national space policy does not grant third parties, any rights to sue. In other words, it does not grant them legal standing. That was another piece of information, or what we call dicta, that was in the opinion that I thought was very interesting. Again, if you want a copy of the opinion, send it to me, and I'll gladly send me your email, and I'll gladly send you a copy. Message me on Twitter if you will, and I'll give with your email address, and I'll send it to you. And if you want to read my full analysis, feel free to subscribe to the Pressy. I'd be happy to have you as a subscriber. Okay, it's a beautiful Friday out there, and it's going to be a great weekend. Spend less time watching videos on social media or watching me, and get out and enjoy the weekend, because summer is very quickly moving along. Have a great day, everybody.